Ladies and gentlemen, welcome to this 11th in the series of Coffee with the Bar. Law and medicine are considered to be the most elite of the five traditional professions, the others being architecture, engineering, and the clergy. Out of law and medicine, the medical field is right now in the forefront of our defense as well as offense against COVID-19. Whereas law has been forced to take a backseat because of various things. The law basically being an interactive profession, especially in our country and state, due to the high levels of population, the infrastructure, and the rising levels of business. This has led to overcrowding of courts, and taking into account all of the above, courts have also been in lockdown with only serious and emergent matters being heard through video conferencing. Courts have, however, adapted to evolving situations, and our High Court, the Chartered High Court, Madras High Court, and the subordinate courts in Tamil Nadu are also adapting to the terrible chaos that has been brought about due to the after effects of COVID-19. And the stakeholders of the legal system, being the bench, the bar, and the general public, with the bar acting as a bridge between the bench and the general public for accessing justice, has a serious role to play during this crisis. Due to the skeletal working of courts, the bar is also at crossroads on various counts, the most important of which is professional survival. Normally, the youngest in a field of business or in a profession, or even among the animals in a herd or a flock, are the most vulnerable, and lawyers are no exception to this rule of the youngest being the most vulnerable. The juniors in this profession are probably the most vulnerable as on date. They are the most affected, and the troubles forced on them by various factors, all of which are directly or indirectly traceable to COVID-19, is the issue that is before us now. Now, this gentleman who enrolled in 1984 and is now the Chief Justice of this wonderful Chartered High Court, from what we have seen of him, quick to laugh and ready and even eager and anxious to encourage juniors, we thought that he would be best suited to present probably what we can call the roadmap for the juniors, his vision of the future for juniors. So to present his vision of the road ahead for juniors, Shri Amreshwar Pratap Sahi, the Honorable Chief Justice of Madras, may I request him to present his view. Thank you.
Thank you, Mr. Sri Ram, and welcome everybody to this nice arrangement which has been made for an interaction between those who really matter for the profession, and more importantly, who have a role to play in this area of public concern. It is true that the topic comes up for discussion during COVID, and therefore I would say welcome to the lockdown period. This is how this era begins. I was trying to find out the meaning of the word lockdown, and it was not available in any other dictionary except Black's Law Dictionary, edited by Garner, where I found that this word was coined in order to cage the most vulnerable of the prisoners in England, to keep them isolated. Lockdown means isolated from other prisoners as well. So I don't think so. We are under any such lockdown, and we manifest ourselves with the best of our abilities in enjoying our fundamental rights guaranteed under Article 19 of the Constitution to express ourselves. And therefore, the word lockdown does not carry any meaning for our views that we interact today. Friends, we are discussing something vis-a-vis the juniors and their fate ahead. Nobody knows his destiny. There are many who try to chart it out, like Hitler, who just struck a knife on his palm because his friends were having lines on his palm. But when he did this, he never knew what he would turn out to be. The destiny that we have charted ourselves and the destiny which we think we have charted out for ourselves through this profession, I believe was ordained by somebody else. But that is a matter of belief and faith. And that is matter of rather personal belief and faith. But the practical aspect is that the destiny or the aim or the ambition which you chart out for yourself is not under your control, and it is definitely influenced by large number of factors in society, possibly more serious factors like the present COVID situation, where it is all a matter of survival of life rather than survival of a profession. But let me tell you, at least the young friends, and this is for the young friends out of my own experience, that this is an incalculably very, very interesting profession. And it is such an interesting profession that there are many more mysteries attached and many more stories attached to this profession than to any other. You are master of what you are serving for the time being. And I encourage you because I believe that one who seizes today controls tomorrow. This is how I look at it from the point of view of the juniors. And therefore, I would begin with the fundamental elements which, in the sense of opportunities, are somewhat of eternal importance. Come what may, whatever be the status of the profession, whether it is this age or the future age of electronics and communications. And I will ultimately conclude when I end that the biggest challenge is not a human challenge or a challenge of nature. It is our own created challenge, and which I think the panelists who are listening to me will agree, that it is the future challenge of artificial intelligence, which will now be staring at your face. Artificial intelligence, once it takes over, you can very well imagine that cases or causes being handled through robots, through other systems, will eventually make you feel that you have become irrelevant. So it is this challenge which you have now to take up, because no longer are libraries very relevant. It is the Google, it is the e-reading, it is the e-court system, which is now taking over globally, and not only in developed countries, but even in developing and underdeveloped countries. Trade and commerce and the language of global communication has brought the world closer, and people sitting even in space are able now to very comfortably communicate anywhere they want to. So therefore, this reduction in the barriers of communication, the reduction in the barriers of thinking, the reduction in the barriers of storage of knowledge, the reduction in the barriers of one-to-one understanding have made possible artificial intelligence now grow something like that challenge which our youngsters may have to face in future. But nonetheless, as I said earlier, there are certain fundamentals and eternal principles which, whatever the stage be and whatever the challenge be, will have to be observed, because I firmly believe, after all, artificial intelligence is a creation of human intelligence. And therefore, the human intelligence, if it remains intact in the sense that we maintain our values, we maintain our understanding, we maintain our traditions, and we maintain those natural instincts which we have learned from our ancestors and which still today hold good. Whatever be the artificial intelligence, it will be mechanical. It will be what we create, not what it will become out of itself. So therefore, the challenge for our juniors today is to understand this roadmap which they have to traverse in the times to come. And this will be connected with pure and simple consumerism, the market which is growing, which wants excellent professionalism and which wants speed, because what we are lagging behind it is the age-old complaint against us that delay defeats justice. Today, even whenever we look at so many things that are staring at our face, adjournments and delays are the first thing that are talked about in society. But again, coming back to the point, in order to meet everything, what is important is that every junior has to prepare himself for the challenge ahead. And for that, you know, life, if taken seriously, it begins anywhere. What I mean to say is, there is no age of learning. For example, when we entered the profession, there was nothing like a mobile. There was nothing like even a good computer. But today, when I'm almost on the verge of my retirement, I find that I have had to learn so many things which kids in my family at the age of 7 and 8 have already learned. This is the huge gap. And therefore, the juniors who are to face the profession ahead, they have to cope up with this, and they have to, in advance, like a war preparation in their war room, chart out very much their own destiny in the light of these challenges, but with those attributes like due diligence, like due patience, like learning the arts of this professionalism. I will talk from the point of view from my experience as an art of persuasion. How does a junior lawyer in the times to come meets this challenge? Now I will place it on the pedestal that when there is going to be such a competition vis-a-vis artificial intelligence, or even better equipped lawyers globally, then what would be that extraordinary element in you, that fundamental element in you, which will allow you to stand alone as against all these challenges? I personally believe that when we talk with each other, when we communicate with each other, then there is something like a dialogue. A dialogue is necessary. You can't talk to yourself and find out a solution. You have to talk to others. And this is what this profession means. When you are talking in court, when you are challenging your colleagues in court, you are entering into a dialogue. And for that, your preparations have to be very substantial. The preparations are the acquisition of the correct law that you are going to speak about. You should be clear in mind, particularly juniors, that don't get into this web of justice and law. The reason why I say so, that man has chosen himself to be today as an individual to be governed by law. Law which he has created himself, either it is through legislation or any form of drafting of laws or codifying of laws. He has chosen to govern himself by it. He is not governing himself by the laws of nature today. And that is what I am hinting at, that in spite of this, that nature is telling us something otherwise. We are trying to govern ourselves according to our own challenges. Let courts open. Let there be physical court of hearing. Let there be this and let there be that. And therefore I say that in order to prepare yourself for this, I will just give you a little hint that this art of persuasion, which is very much necessary in our profession, is clearly connected with the other professions of relating to consumerism. I'm not saying that our profession is something like a business or a trade, but nonetheless, keeping in view the public perception that one has today about courts, about getting early justice, quick justice, instant justice, instantaneous justice as compared to other forms of governance, they want you to act fast. Patience is giving out and is also very low. So in this age, this is one of the challenges. And therefore, in order to develop this art of persuasion, what I have experienced is, and I have heard it so many people speak, that a human being's body, whatever it gives out, it smells, whether it is perspiration, whether it is a cough, or whether it is any form of excretion. That smells, undoubtedly. It has no fragrance. But there is only one thing which emanates from us and which gives fragrance, and that which is permanent. And that is your voice and your language and your tongue. This persuasion is the very foundation of our profession. What we speak, how we speak, how do we think, and how do we create an impact on others. It is just like the salesman who with his sweet tongue gives you something more than what you intended to buy. I say this and I repeat it again, don't get entangled into the theories of law and justice too much. A little bit of understanding is necessary. The reason is, what we are dealing today in courts and what we are dealing in everyday life, as I earlier said, is human-made law. So we are dealing with law, and judges are passing orders and are delivering, rather handing down decisions. This is not essentially justice. I'll just clarify this to you with my understanding of it. Justice, somebody says it is abstract, somebody says it is subjective. There are many definitions which have been given by many philosophers, many political scientists, many legal luminaries, many experts in this field, many judges and stalwarts. But I remember Dante Alighieri. He said, justice is a certain straightening or rule. Justice is a certain straightening or rule, rejecting the oblique on either side. So this is how justice is delivered, and this is how it is understood by human beings. But I personally believe justice is done by the Creator and the Almighty, and it is like our destiny, not in our hands. We start very early believing that whatever we are doing is just. As a matter of fact, whatever we are doing is legally just. Law authorizes us to make you believe that this is just. And therefore, the Supreme Court also says in a 1994 decision that whatever is in accordance with law has to be treated as just. So this is just a prelude to give you a little bit of understanding on the clarity of legality and justice. So just don't confuse yourself with this, because you are on the threshold of your career. Leave this to others. Your duty and your aim at present is to establish yourself in the profession and to have something tangible in your hand to talk about, which are known as cases and clients. Now it is here that you have now to understand that how to have these things in these tools in your hand, because this is the real material on the basis whereof you can even think of mapping out your road. You have to imagine big, but please remember, even if you get a very small case or a very small problem to handle, the first lesson is do not refuse any case. You have to be at times in this profession pretentious, and there are many who are as sly as a fox. The reason is very simple. It is not because of the bad qualities of the fox. It is because of that good quality which you should try to identify, and which in my experience has been your flexibility to understand things. When you enter the profession, I'm going to practice on the civil side, on the criminal side, on the corporate side, on the tax side, on this side and that side. There is no such side for you young people. There is only one side, and that is your focus on what problem you are faced with, and that is your real challenge. So therefore, and of course in the background that I said, when artificial intelligence is running in fast, and I will not take much of your time to illustrate this, you very well know today, after we have adopted this artificial intelligence sort of a thing as a virtual court in deciding motor vehicles violations. Now at the tap of a button, a policeman challans you, and you have justice, immediate justice, payment given, and you log out and you are back home. This is how things are happening, because they don't need a lawyer there. Your help is not required there. So there would be many more things like this in the offing. And believe me, the government is thinking fast on these lines to bring about major changes in the law. The law is going to be vitally changed on this subject. We have been consulted many a times, and we know that whichever government it is, it always wants to remove any legal obstacle. The reason is twofold. One is domestic problems, the other is international problems. Investment in business from outside has to come, and if they find that India is a very litigious country, they run away from here. Similarly, even if an indigenous entrepreneur wants to do something, or even a farmer who wants to take a loan, he now thinks twice that God forbid I will not be involved in litigation. So the government also is thinking of framing such laws where there is an automatic transmission of solutions. So therefore you have now to learn these automated versions of delivery of legal justice. This is your challenge and you have to learn it. These things are coming fast. The research papers of Indian Law Institute, the research papers of many more advanced institutes of learning, right from Singapore, right from Japan, right from Germany, you will find they are flooded with such suggestions that you will come to learn very easily, and they are going to be adopted by whatever government and whatever form of government we are going to have in future. So the challenge is about these things in future, particularly with regard to our junior members. Now coming to understanding of this art of persuasion that I mentioned earlier, I will share with you a very old anecdote about Mr. P.R. Das, who was one of the famous lawyers in the Patna High Court. And I have mentioned it once or twice somewhere. He had the gift of the gab, the gift of the mind, and the gift of persuasion. He was entrusted with a brief by a big landlord to fight his case in a regular first appeal before the Patna High Court. He was appearing for the appellant. And we started the narrative. Now I am emphasizing this word narrative. This is also very important for professionalism and in the challenges to come ahead. How you place yourself, how you place your cause, how you, in the most witty and short form, try to bring about and captivate the person so as to believe in you that what you are saying is correct, which is the art of persuasion. And here the story of P.R. Das is very effective. He started his arguments in the morning at 10:30, and this was in the good old days, early 1950s. He commenced his arguments, and lunch, which is announced at 1:30 in that High Court, he had completed almost the best part of the argument. But unfortunately, that was an argument which was for the defendants. The appellant was fussing and his junior was failing to persuade him to stop. His junior was no one else than the person who later on became Advocate General of Bihar, who told me this story and who is no more in this world, Mr. Balbhadra Prasad Singh. He said, we kept on reminding him, sir, you are arguing the case of the defendants. And he unmindfully, engrossed in his argument, advanced every possible best legal position that could be staged on behalf of the defendant. During lunch hours, his client told the assisting counsel, sir, now I am bound to lose the case because I find that everything has been argued by him against me. So kindly, could you just clarify? I am very jittery on this. The assisting counsel was also equally jittery, not that, but he did pick up the courage to tell Mr. P.R. Das that, look here, sir, you have argued all these points which was for the defendants. But we prepared it. He said, yes, sir, you have prepared it. And I don't forget, but you had prepared it from this point of view as to how you will answer this. Oh, don't worry. And then when the bench assembled at 2:15, he commenced by saying, "My lords, I have advanced, and I believe that my friends on the other side would also agree with me that this is the best possible case that can be put up by the defendants. And therefore, your lordships might have a feeling that the appeal deserves to be dismissed. But kindly allow me now to commence my arguments." And he reversed his own arguments by the end of the day, and the next day the appeal was allowed. So therefore, there is no better or superior power than the human brain. And that is why I always encourage all those who come to this profession that when these topics are given for any discussion, the road ahead or what you have to find out, I will say the road is very friendly and very conducive ahead. Do not feel distressed. The reason why I give for this is, my friends, the legal profession is a profession of distress for any lawyer right from the beginning. He has to struggle wherever he is. There are very few who get it in a silver plate with their lineage or background behind them. But most of us have traveled into this on account of our own volition. And I'll tell you from my own experience, I'm sorry I'm running out of time, but just 5 minutes. That is that I was a member of an affluent family, and I did not have the disadvantage of not supporting myself. But the only disadvantage that I had was that I had no lineage in law. I had nobody, as a matter of fact, in my family who had stepped out in any profession for the past more than 100 generations. So I was the first one to get out and understand what it is. And I tell you, it is humility which pays in this profession. It is not surprising for me and for you also that I learned the very first lessons of drafting a listing application or the drafting of a delay condonation affidavit from my own clerk who was just class 10 pass but who had a beautiful handwriting. There are many slips between the cup and the lip, but I must tell you, you have to pick up every thread wherever you get. Please do not hesitate in taking help from anybody, not even your own colleagues. And please remember, give respect to your seniors from whom you have still to learn a lot, and respect to the courts, of course, which is a different topic altogether about which I will not talk today. But nonetheless, your road is also full of many hurdles. But at the same time, as compared to our period and your times, you have everything at the tip of your fingers. And therefore, you now cannot say that I don't have that advantage. Rather, we were at disadvantage because we had to search out rulings manually, physically, and without there being any help from any corner, making our own notes and preparing our own diaries, jotting down our own precedents. There is a last word which I would like to part with you, and that is very important and which I have heard from others, and it is from my own experience. As I speak to you, I am surrounded by my own books. Please understand, legal learning is not the end of this profession. To my mind, a wider learning of life, because unless you read life, you cannot learn about its difficulties. And to learn about life, you can travel, you can talk, but there is a very good source of learning about life from these books. Please widen your horizon by reading books from every field and every sort of material that you can get hold of, because you have to learn both from the good as also from the bad. You might have to fight a case about a libellous document. So you have to read something about that also, so that you understand it, because you have never had the occasion to deal with libel yourself. But unless you study material on it, the literature on it, and last but not the least, please do not forget to enter into a dialogue with anybody whom you find of any interest, as I would end my whatever I had to say in this time that has been given to me. I was walking in the rainy season at Allahabad on a road, and suddenly rain started pattering heavily with big drops. A rickshaw puller was going by just besides me. I had no umbrella, so I just pushed myself aside beneath a tree. And the rickshaw puller also did not have any umbrella. And he told his passengers, look here, is there anybody who is a bigger gunda than this Almighty, who is trying to whetten us in these hard times? So I'm telling you of experience, that rickshaw puller virtually opened my eyes, and this is what we are facing today in COVID. You have defied nature, and nature has told you you are irrelevant. Thank you very much.
Thank you, sir, for that wonderful but good enough to cover all the necessary basics and short enough to be very interesting. Thank you very much. I definitely did not give you any time frame. I definitely cannot, but very nice. Thank you. We just have a few questions, if you can answer.
Yes, but before that, I'll
Sure.
just say one comment more on your last compliment.
Sure, sir.
I was arguing once, and I can take his name very comfortably. There was a senior lawyer in Allahabad, Mr. Siddheshwari Prasad, late Mr. Siddheshwari, he's no more in this world. So he used to chew his mouth while expressing himself in very chaste English. While he was conducting a case before a division bench, one of the judges was finding it slightly impatient. The arguments were being prolonged. And since his style was to chew words, he was taking slightly longer period than what was meant for that case. So they just said, yes, Mr. Siddheshwari Prasad, you come to the point, you come to the point. He just stopped midway and he said, my lords, Sir Charles Russell, the great lawyer, trial lawyer, said that the arguments of a counsel should be long enough, like a lady's skirt, to cover up her gracefully, but short enough to maintain your lordship's interest.
Okay, and since you have said that, just an off-the-cuff question.
Yes.
How important is humor in courts? And when on the bench, would you appreciate it coming from a junior? Because there is a very thin dividing line between trying to be humorous and being slightly impertinent.
Yes.
How have you dealt with it sitting on, how have you experienced it? How have you dealt with it sitting on the bench?
This has a twofold answer. One is the background from which you come and the company you have kept, which is, in short, I would say, your upbringing. And the second is your own intellect, which you have acquired either as a student or as a lawyer, which of course I would say is divine, because this is only by the Almighty's blessings that you get this talent how to talk. But one thing is certain, what is known in our Indian culture is sanskar. That is developed because of having your ability to politely reject something or vociferously accept something. So when you agree with somebody, you are very vociferous and that pleases him. But when you are at disagreement or at dissent with somebody, you very politely say, no, no, I'm sorry, I'm unable to persuade myself to accept your. Now, this is this balance of language and understanding which you have to develop in order to understand the balance between wit, humor, and a little excess of that. This is how you develop it. The second is your competence and your own intellectual position to understand these things. Now, that is absolutely individual. Because if you are all the time engrossed in your case without understanding the subtlety of any statement, this can come only through court craft and understanding or listening to people. The same way I mentioned Mr. Siddheshwari Prasad's response as to how long an argument should be. So this is how you learn things which are not taught in schools, which you will hardly find in all the books, because these are almost instant and instantaneous reactions of the mind, human mind. So therefore, what one has to be careful is that before one speaks or reacts, he should be or she should be capable of understanding this, I would say, balance of courteous language in wit and humor. So that balance has to be by way of practice, and you are right in saying that if courtesies are maintained, cases can be won even without law.
Right. Now, coming to a far more topical issue, this thing about video conferencing and all that.
Yes.
There's been a lot of contentious arguments for and against.
Yes.
But with reference to juniors,
Yes.
do you think that video conferencing is here to stay?
I will simply say yes, for the simple reason that there is hardly any lawyer, whether it is a taluk court or a district court or the high court, where the lawyer does not have or his clerk does not have a smartphone. Each one of us have it, and they are entertaining themselves on it, and they are also discharging their professional duties on it. So there cannot be an excuse that we are now foreigners or aliens to it. The reason is, even if you go to the Coimbatore vegetable market, the entire transaction is on telephones. Even if you go to the flower market, the petty traders, or even a migrant laborer, one who has to talk home, he is talking on telephone. So therefore, this technology part is not an hindrance. What is hindrance is its utility and the infrastructure available for it. That we have to understand. So therefore, this is come to stay, but with the infrastructure. For the time being, the entire infrastructure is not there. For example, towers are not available in taluks, so connectivity might be a problem. But this problem will be got over very soon, within 5 years to 10 years. All this will be, these barriers will be eradicated, because people are very impatient about it and they want everything to be done fast. Even the government is trying to come up, all governments, whether they are provincial or the central government, to provide with this. So therefore, Alibaba has invaded you everywhere. Don't be scary about it. And the lawyers, I must say just one thing to clarify in their mind. The way we are talking here, video conferencing also complies with the principles of natural justice. After all, what is hearing? What is physical court hearing? Or any form of hearing? It is adherence to the principles of natural justice. Now, please tell me, while I am hearing you, and while you are either arguing a case or responding to me, is natural justice being violated? We are hearing, we are understanding everything. It is just a screen. It is only the methodology of communication, which I don't think so is a legal barrier, or even a barrier which cannot be crossed over. And I'll just tell you a small anecdote. that athlete I remember by the name of some Johnson, who was one of the best basketball players of United States of America. Somebody interviewed him and said that when you are faced with a bigger challenge, what do? He said, it is very simple. If you can't walk through the ball, please learn how to climb over it. So we will learn how to climb over it. There is, my point of view is to look at every problem from the positive point of view, not from the negative point of view that this is going to harm us or this is. Now you see the other side of the coin. It might be a disadvantage to senior lawyers because a junior lawyer sitting at Coimbatore can, through email, file his bail application right from there under 439, and he can get an order sitting at Coimbatore. Mr. Shri Ram may not be, is not likely to be engaged in it. But the other way around also, Mr. Shri Ram sitting in Chennai can very well connect himself to the Supreme Court. And he can, at the time of mention, get an order from the Supreme Court without even traveling to Delhi. So these are two sides of the coin, which if you look at it positively, you will find that, of course, it is time taking. This technology has come to stay, and once it stays, people will start enjoying it. And the logic, the crude logic, or rather what I would call it, the distinction between culture and agriculture. The crude logic is, if there are some old people, they will remember that when the railways came, they ran to temples to worship God that a demon has come. And what are railways today? When the automobile came, people ran away from the roads, something strange is coming. But what has happened to automobiles? Now these are things of revolution. And whenever there is a revolutionary idea, it is bound to face resistance. And it is facing resistance, no doubt. But that resistance is in a different form. Once it gets easier, and I must inform the viewers, today only my E-Committee of the High Court got together with the Secretary of the government in order to plan out an app on which all paperwork can be populated on one site and through a different server, giving an independent corridor. Now we have begun work on it. The sooner we get it, it will take time to travel to district courts and to taluk courts, there is no doubt about it. So therefore, rightly so, the Honorable Chairman of the E-Committee of the Supreme Court also said that physical court hearing and the combination of physical court hearing and virtual courts has to be there. Physical courts cannot, and there are some matters very, very essential which have to be heard given a personal hearing or physical hearing. But that would be very, very minimal now, maybe 10% of the criminal cases itself. So therefore, to say that this will be something antithetical to our profession or to this entire system may not be correct.
Okay. Lord, just to clarify one thing purely in a lighter vein, but it is an absolute fact. If somebody wants to engage Sri Ram in a criminal matter, that would be very foolish.
No,
because
not at all.
I will tell you why. If I argue a criminal matter, the client would get 6 months. If he argues it by himself, he would get 3 months only.
There you are questioning the wisdom of the judge in understanding the lawyer poorly.
Okay. One more thing which is very topical right now, this question of artificial intelligence which you brought up. Probably a week ago, I read about three districts in China which have come up with artificial intelligence judges run courts.
Yes.
And surprisingly, the reports are to the effect that a commercial case or a commercial dispute takes around 28 to 32 minutes
yes.
at probably 1/10 of the cost. I mean, don't you think that if that comes at some point of time, it would
Yes.
be a real threat to juniors?
Not at all. That is why I said that nothing is out of course for lawyers. And therefore, they had not only to read law, but to read all multidisciplinaries. There will be many more vistas in life. This threat is there from day one when this profession came into existence. That competition will be there. There would be many more lawyers. We have 19 lakh lawyers today. They are all being fed. They are all there in the profession. So therefore, opportunities will come. You have to keep, and as probably I had also told you that one of my seniors in Allahabad, when I joined the profession, he said, Sahi, what you are planning to do? I said that I'm planning to go on the civil side. Then he said, there is nothing like a civil side or a criminal side or a tax side. It is just like a knife, sharp. The edge is so sharp. It can also cut a pumpkin. It can also fleece a rooster. So you can do anything with that knife. Please don't forget this. And I have seen it with my own eyes, heard it with my own ears. Mr. P.C. Chaturvedi, who was one of the topmost lawyers in Allahabad on the criminal side, argued the constitutional habeas corpus petitions during emergency in such a beautiful way that Allahabad High Court was one of the leading courts that gave that judgment by Justice K.V. Asthana. So therefore, I don't believe this, that a lawyer practicing on this side or that side. And I tell you, on the lighter side, there was one Mr. Rai who was a practitioner of the civil side. And when I entered a profession, I had a very poor client who could pay very little for a bail. So I saw him as a respected man. I said, sir, there is a bail. Then he said, this is not a bail. This is an appeal. The bail is in the appeal. Yes. So he said that, all right, I'll do it. After it had been drafted, my client told me that my lawyer in the district court has told me that he's a civil lawyer. Don't worry. I was shocked from within that I have engaged somebody who is wrong. And when Mr. Rai entered, I remember the name of the judge also, Justice V.N. Verma, a very sober and a very learned judge. When he appeared before him, he said, my lords, this is the criminal appeal, and this, and I'm praying for a bail. The only thing that he said was, right from there, I could hear it clearly. Congratulations, Mr. Rai, on your maiden adventure. Admit bail. So I wish you good luck, Mr. Sri Ram.
Thank you. Probably a few days ago, I read the article written by Dr. N.V. Badrainath, the presiding officer of the Debts Recovery Tribunal.
Yes.
About young lawyers, which is very useful now, and you had probably reviewed it along with the letter.
A very humble way of expressing my views about it, but it was very well written.
Yes, and therefore, on a personal note, when you were a junior, I mean, you obviously enrolled in 1984, probably for the first 5 years. Was there any incident or something that changed your perception or your progress in the profession?
Yes.
Or was there anything?
I'll tell you why. I never asked, or I was never rigid about charging of any fee from any client. And that was because of my experience in those first 5 years. A second appeal came. I still remember that case very lucidly. And it was a second appeal from the district of Bijnor. It arose out of a simple suit of eviction. The dispute was about the validity of a rent note and the holding over of the lease period. Very simple case. It was all covered by findings of fact. I had absolutely no case except the usual ground in second appeal that the trial and the appellate courts have read the evidence in a way which amounts to perversity, and therefore this is a substantial question of law. This is how I tried to frame it somehow or the other. But I tell you, I remember the case Sukho versus Nathu. It is still in my mind. I've never forgotten it. That lady Sukho was a 60-year-old lady, and she came to engage us, guided by some lawyer of the civil court. After I read the papers, I was not very confident about it, and I asked my senior. Then I told him that this is the position. So he said that there is one old Privy Council case. I will try to make out a case. And I still remember that point, the plea of jus tertii, which many of our juniors may not be knowing today. So that he said that I'll try it. And the judge was, I remember it still clearly, Justice A.P. Mishra, who later on became a judge of the Honorable Supreme Court of India. We prepared the case, and my clerk, he started pestering the client for fees. So that was in 1984, when I had quoted 550 rupees. 50 rupees as clerkage and 500 rupees as fees. Now, those days, of course, what happened was really heartrending. She took out a small packet from her shirt, it was a shirt which she was wearing, and it contained jewelry. So she gave it to my clerk. I have only this much. Now, when my clerk came to me, he said that she says that she has only 60 rupees and this jewelry she has brought. I said, please return everything. And till today, I believe that was the changing point. I'm built up because that was the changing point. Yes.
Okay. But very, very refreshing, I must say, to see a constitutional authority, a judge of the High Court, not only recounting such a thing, but also being seriously emotional about it. Thank you very much for that. Lastly, probably two things. It may not be exactly concerned with the topic that you have probably expressed your views on.
Yes.
But all those young lawyers who come in nowadays,
yes,
not many of them seem to be enamored of the profession, be it for whatever reasons. It could be even monetary. Most of them try to go in for jobs. Do you think that the law schools are doing their bit or are doing enough to ensure that people do come into the profession as such?
There is the answer that I would like to give begins from the nature of the law schools that we have. Now, on the one hand, we have national law schools, which are churning out students of very high quality. And they, in the sense, are so well versed with everything that they create, the first impression that they create is that they really know the law that they are talking about. But on the other hand, we have law schools, and probably in our conversation, we had discussed about Usha series. So it is there which the difference comes into. The standard of education, which is now available for the past 20 years, this section, which has had the education through Usha series, may not be able to cope up with these things. But the best of the education that others are getting from universities, national law schools, I think they are any match to international standards if they are given that opportunity. So therefore, I would say that it is because of this that this disparity has arisen. But nonetheless, I am very much optimistic about it in the sense that even those who are lagging behind, what we should work upon is, and I tell you this, I had spoken about it, and it was also experimented in the Bar Council of India when I had gone there, this system of continuing legal education for those who are lagging behind, particularly in district courts and in taluk courts. For that, what you have to do is, and that was experimented by the Bar Council member who was there from the state of Maharashtra. Every junior cannot get a senior. That is the problem. Or a senior has 10 juniors with nothing to pay or something like that. They just trail behind, have a cup of tea and some snacks at the end of the day and go back home. This is what is happening in lower courts. We know that everything, the reality is there. But how to make the best use of them or teach them how to learn? So that Bar Council member introduced a system that a senior member of the bar would come up every month and tell about his experiences of cases that he has been handling, either in the taluk court or in the district court. And those juniors who do not have any seniors can sit and have the benefit of that experience in order to learn it. So this was one method which was quite congenial. But now with this technology that you have, you can get hold of any senior, any lawyer, and you can begin with this talk. And I would suggest that if this is connected with, supposing you are connected with the civil court in Cuddalore, you can ask your colleagues that I'm arranging for a talk on this day, and we will take up now, say for example, adverse possession, section 64 and 65 of the Indian Evidence Act will be discussed. So now adverse possession cases are very much there in civil courts. So those lawyers will gain from you what is adverse possession, what is section 64, what is section 65, and how to bring about a good point in a case. So this method, this very technology itself will help you. But even otherwise, if this technology is not there, the seniors at the district courts, or even if some seniors who at times once in a 6 months are going to the district courts, they can arrange for this and tell the people that this is the trend of law in the Madras High Court, instead of telling them that this is what the judge is giving these days.
Okay. So just a follow-up question of your from your answer about the unequal playing fields due to national law schools and the other law schools.
Yes.
In one of our previous sessions, Justice Jagdish Chandra had actually suggested during one of our sessions that he had suggested that instead of taking interns from only these national law schools and premium elite schools, you should be able to take students from 4th and 5th year students from the districts, from the government law colleges. Therefore, by making them interns, by giving them sort of work spread over a period of 3 months, 6 months, or 9 months in their final year, the inequalities will be slightly more balanced out. Do you think that that would work?
You see, the other factors which might come in between is this admixture being brought about, and in what manner. If there can be a program, you see what happens in schools is when you take a child for admission, they screen him and put the best ones in one section and the other one, medium ones in other section, and the slow ones in the other section. But there are schools which do not carve out any such thing, and their courses are designed that each category of student gets the basic minimum education. Rest of will depend on his other superior abilities or capabilities. But they have the best of faculties in each class. So now this is where the difference comes in. If an institution has good faculties, then the best of the teachers can always teach the worst of the students. This is what I have seen. This arrangement, if made on that ideal level, can work. Otherwise, this is also dependent upon the type of examinations that we are having today, and the way examinations are being conducted and results being declared. Well, that is more of another topic of legal education, which we can discuss later. But
we will keep that for another webinar.
Yes, why not?
So thank you very much, Justice A.P. Sahi. Thank you very much for that warm, very emotional, very open, and most importantly, peppered with so many anecdotes and incidents. Thank you so much for sharing your view about how the road ahead is going to be for juniors, number one. Number two, how juniors have to equip themselves. Number three, the challenges faced by juniors. And number four, the qualities that they should be able to acquire at least over a period of time. Thank you very much for taking the time, effort, and the trouble to appear on our session. Thank you very much.
Thank you very much. Thank you, everybody.